Well, good afternoon and welcome everybody. Thanks for joining today's webinar on navigating federal healthcare laws and insurance recovery. For those of you I've not met, I'm Martha Jacobs and I serve as Aon's National Healthcare Industry Leader. And I've been fortunate enough over the years to work with the McGuireWoods team to help our mutual clients as they navigate the healthcare regulatory landscape. And collectively, we thought that the timing was appropriate to host this webinar to provide an update on what's going on in the enforcement arena, but also really to cover a few key critical issues. So today we're going to talk through some fundamental issues around the False Claims Act, anti-kickback statute, and the Stark Law. But critically, we're going to also talk about what's coming out of the new administration and their enforcement priorities and trends. And then lastly, we're going to talk a bit about some ways that clients can actually transfer this risk and look to some of the options that are out in the marketplace to pursue insurance protections. So with that, I'm going to turn things over to Mindy Sauter at McGuireWoods to kick things off.
Thank you, Martha. I'm Mindy Sauter. I am a partner in the Dallas office of McGuireWoods. I was a former federal prosecutor with the Department of Justice where I worked on the healthcare fraud strike force, and since then have joined McGuireWoods and work in the government investigations and healthcare space, and appreciate the time to speak about the different federal healthcare laws that we are seeing in play right now. And we're going to drill down specifically into a couple of them and give some examples as we go through. So we'll start out with the broad overview of the different federal healthcare laws at play. We see the False Claims Act, anti-kickback statute, and the Stark Law are the three that are most often talked about and probably the ones that are most easy to recognize. The False Claims Act prohibits knowingly presenting fraudulent claims to government healthcare programs, and it carries with it civil, criminal, and administrative penalties. The anti-kickback statute prohibits providing or accepting anything of value that's given to physicians to influence patient referrals. And like the False Claims Act, it also has civil, criminal, and administrative penalties that follow it. The Stark Law is a little bit different. It prohibits physician referrals to medical service providers where they have a financial relationship that are outside some of the enumerated safe harbors and applies to Medicare only. The Stark Law also only has civil and administrative penalties that are associated with it. Additionally, we see the Civil Monetary Penalties Law, which actually goes and speaks to federal beneficiaries. It prohibits giving anything of value to beneficiaries for the purpose of influencing that beneficiary to order or receive items from a particular provider, and has civil penalty associated with it. We see the Social Security Act also in play, which prohibits knowingly abusing Medicare or Medicaid and carries criminal penalties. And then there's just the straight criminal healthcare fraud statute, which prohibits knowing and willful abuse of government healthcare programs like Medicare, Medicaid, TRICARE, and carries criminal penalties. Of all of those that I just walked through, we're going to break down and talk more specifically about three of them. And then after we go through just a general overview of each of those, we'll give some examples and talk through those further. So the first one is the False Claims Act. It's probably the one that's the easiest to recognize and the most talked about. And we are seeing a good deal of enforcement on the false claims side through the government. And I believe that we'll continue to see likely a large uptick in these cases. The False Claims Act prohibits knowingly submitting or causing to be submitted false claims for payment to a government program. The bad thing about False Claims Act cases is that the penalties are severe and they can be incredibly burdensome for any company that gets wrapped up in one of these types of cases. In the civil side of these, you'll see often that the government can recover 3 times the amount of any of the damages that are associated with an FCA case. And then more importantly, they can also claim $5,500 to $11,000 fine per violation. So every single claim that's submitted to a federal healthcare program under a False Claims Act case can carry a penalty with it in that range. There's also criminal penalties for FCA cases that include up to 5 years imprisonment and also criminal fines. And then there's administrative penalties. In some instances, the government will move to exclude the company or the provider from being able to participate in federal healthcare programs. And also, there are a lot of instances where when these cases come about and settlements ensue, there are also a requirement that you enter into a corporate integrity agreement, which is basically an agreement that you have to follow specific compliance and regulatory rules over the course of a certain set number of years. And you have an entity in there that's regulating and ensuring that you're doing so. I'm going to kick it off to Mike Elliott to go through the next one, which is the anti-kickback statute.
Well, thank you, Mindy. Good afternoon. My name is Mike Elliott. I'm a partner in the Dallas office of McGuireWoods, working in the government investigations and white collar. And just like Mindy, I was at the Department of Justice, where we did a lot of white collar healthcare enforcement work. In fact, Mindy was my trial partner at the Department of Justice. So we've done this work for quite some time. So the federal anti-kickback statute is probably one of the most, if not the most important statute that goes hand in hand with the False Claims Act that Mindy described. So that law, the federal anti-kickback statute, prohibits intentionally offering, paying, soliciting, receiving kickbacks, bribes, rebates, and cash or kind. And the issue is like they want to prevent referring patients to providers for an item or service covered by Medicare or Medicaid or any other federal healthcare program. So that's important also to note that it involves every single type of federal payer, the Department of Labor, Department of Energy, Medicare, Medicaid, veterans, everything. There's also details related buying, leasing, ordering any item, service, or facility covered by any of those programs. All of those issues are subject to the federal anti-kickback statute. So it's very broad and far-reaching and utilized a lot. So the purpose of the anti-kickback statute is that Congress is under the thinks that kickbacks cause overutilization of health services, increased costs, corruption of decision-making by physicians, patient steering, and then also unfair competition among health service providers. You can imagine if someone's paying kickbacks and they're doing a lot of business, they're doing a lot of business because they're paying kickbacks. And so the government tries to prevent that from happening. There are 4 elements to the anti-kickback statute. The act has to be intentional, deals with the payment or receipt remuneration for the purpose of inducing referrals. That's the key, right? The key is inducing the referrals of patients. It also deals with medical goods or services funded by a federal healthcare program. So the intent element of the statute is that it has to be knowing and willful, which is different than a specific intent. That doesn't mean what it means is that you don't have to knowingly think, if I pay this person, I'll be violating the anti-kickback statute. Like, that is not required. What is required is that you know that you're paying for something inappropriate or receiving something of value in order to give something inappropriate. That is knowing and willful. And there's obviously a lot of legal cases related to this and a lot of trials related to this specific issue and what an individual's intent was. So what is remuneration? So it's defined very broadly. It can be direct or indirect, but generally what you see in cases is that it involves discounts, rebates, gifts, provision of free or discounted medical equipment, payment waivers, consultation fees, above or below market lease payments. You see that a lot. So those are the types of remunerations that you would see in an anti-kickback case. So to break it down, here are some examples. A doctor's being offered a part-time office position at the entity's expense. A medical director contract is executed without the need of documentation or the work performed. Like, the person would get $5,000 for nothing. And what the government would say is they're getting paid for referrals, and that's a violation of the anti-kickback statute. There's issues related to routine waiver of copays, deductibles, co-insurance, giving away free surgical packs with purchase of medical devices, free CPT training for a physician's staff, paying physicians to attend conferences for their specialization, and percentage-based compensation to medical marketers. This last one is very important. That is something that you see very, very frequently, and the government has a keen interest against in enforcing that, and they have a developed process in order to prosecute those types of cases. I think also the interesting thing, just like the False Claims Act, the anti-kickback statute, it has civil implications and criminal implications. For the False Claims Act, what you mostly see is that the anti-kickback statute would be a civil violation, causing a violation of the False Claims Act. But there are tons of anti-kickback statutes that are criminal cases as well. So courts have come down to what they consider to be like a one-purpose test. The anti-kickback statute is violated if one purpose of the remuneration is to induce induce federal program business, even if that is also providing compensation for lawful services. So there has to be the one purpose has to be to induce federal business. And there may be other reasons, but if the government can prove that that is one purpose of it, then it is violative of the anti-kickback statute. So the scope, like I said, is very broad because it deals with every type of federal payer, but it's also very broad and different than Stark, which Michael Podreski will talk to, because the anti-kickback statute doesn't just deal with physicians. It deals with doctors, patients, medical service providers, medical marketers. So we're talking about licensed individuals, nurses, whoever, and then lay people without licenses who are causing these types of illegal relationships. The statute applies to all types of transactions, regardless of whether the government suffered any actual losses or whether the patient received otherwise proper medical treatment. So it's not sufficient. If something is paid through a kickback and a patient was referred and that patient went to the best doctor in America, that is still violative of the anti-kickback statute. And if that person got outstanding care, that is not an excuse or something that will get an individual or group out of some type of trouble. The penalties, criminal penalties, the violations of the anti-kickback statute are felonies, 5 years in prison, $25,000 fine. Civil contains monetary penalties. There's also administrative penalties, most specifically like the exclusion from participation in any federal healthcare program. So let's say like if you're a marketer and you get in trouble for violating the anti-kickback statute, you could be on a list saying you are prohibited from participating in any federal healthcare program. And that list is updated, and that is something that compliance groups check constantly to see who is on the list, in hiring decisions, in merger decisions, all those things are critical. So the anti-kickback statute and the False Claims Act go hand in hand. And they go hand in hand because if there is a violation of the anti-kickback statute, it is an automatic violation of the False Claims Act. And so that is how a lot of False Claims Act cases are built, on proof of violating the anti-kickback statute. They go one right after the other. There are certain statutory exceptions to the anti-kickback statute, bona fide payments to W-2 employees, discounts, payments to purchasing agents. There are certain safe harbors that I'll show you in the next slide. There are certain types of risk-sharing arrangements, and there are certain types of prescription drug discounts for beneficiaries in what's called a donut hole or coverage gap, which has been rectified in January 1st, 2025. But I think before we go to the next slide, I think it's important to know that this statute, just like a lot of statutes, but this statute, the Stark Law statute, those are incredibly fact-intensive and specific statutes. And that if someone is going to say, oh, this is okay, it doesn't violate the anti-kickback statute, and that person's not a lawyer, like that is not good advice. This is something that's very specific and has to be looked at on a case-by-case basis. And I think the statute goes to what I just said. All of these safe harbors are listed in the anti-kickback statute, and all of them are incredibly specific and require certain things to be met in any type of contract or any type of relationship. And so I'm not going to read all of them, but you could see that if someone's saying, oh, I meet a safe harbor, let's say I meet a cooperative hospital service organization safe harbor. Well, someone has to really dig into that, and that is the subject of some significant legal analysis. And I think at this point, I would turn it over to Mr. Podreski.
Thanks, Michael. Good afternoon, everyone. My name is Michael Podreski. I'm in our white collar group based out of Washington, D.C. I joined McGuireWoods 4 years ago from the civil fraud section at the U.S. Department of Justice here in D.C., where I prosecuted False Claims Act cases, most of them healthcare related. So I'm going to talk to you, provide some compliance tips, talk about the Stark Law that Michael Elliott previewed. So OIG provides the following tips for ensuring compliance with the anti-kickback statute. 1, use a safe harbor. 2, remember the one purpose test. There might be other legitimate reasons for referring patients. The entity that's receiving the referrals may be the, may have the best reputation in the area, but so long as a single purpose is to remunerate for referrals, the one purpose test will apply and AKS liability will lie. And then provide fair market value for any actual necessary services and document that and document how you apply the safe harbor and the analysis for that. So turning to the Stark Law, sort of, the AKS's cousin with a narrower focus and a more limited application, but for providers that take Medicare and Medicaid, still takes a significant bite. So the Stark Law is often referred to, the Stark Law is a nickname for the physician self-referral law. It prohibits a physician, so it doesn't apply to other providers, from referring Medicare and Medicaid patients to a designated health service provider in which the referring physician or his immediate family member, which you'll see is defined very broadly, has a financial interest, unless a statutory exception applies, sort of akin to the safe harbors in the AKS. And it bars designated health service providers from billing Medicare and Medicaid for medical services performed pursuant to a prohibited referral. So you can't bill for services that are tainted by a referral that violates the Stark Law. So like I said, it's more limited in scope, the anti-kickback statute. It's civil, not criminal. It only covers referrals from a physician, only applies to Medicare and Medicaid, so doesn't even necessarily apply to other federal health care programs like VA or TriWest, TRICARE. Only covers medical services that are listed as designated health services, and they're defined as such. And statutory exceptions limit the scope of the law, but like the safe harbors in the AKS, as Michael indicated, the application of the safe harbors is usually a very complicated analysis that is fact-based and requires the review and guidance of a educated professional. So definition of a family member, it's not just your immediate or nuclear family. It does include husband or wife, parent, child, or sibling, step-parent, child, or sibling, in-laws, grandparents or grandchildren, even spouses of grandparents or grandchildren. And the current list of designated health services, therapy services, lab services, imagery, durable medical equipment, nutrition services, home health services, and prescription drugs and inpatient, outpatient hospital services. So not the full list of services subject to referrals, but this probably covers, I haven't done the research, but this probably covers the majority of ancillary services offered by most providers. Two standards of intent. Unlike the AKS, which is broader and is a criminal provision and has a criminal intent requirement, the willful and knowing that Michael discussed, the Stark Law is a strict liability provision. So though its focus is narrower, because it is civil, it has a looser intent requirement, essentially no intent requirement to violate the Stark Law. So physicians and designated health providers are strictly liable for reimbursing the government for any monies received in violation of the Stark Law. No intent or knowledge is required for liability. Now, physicians who knowingly violate the Stark law may be subject to additional civil and administrative penalties. So for strict liability, the remedy is payment denial and an overpayment and the creation of an overpayment refund obligation, which pursuant to the Medicare overpayment rule, can put a provider in a tight spot where if they become aware of a Stark violation and that a significant number of claims that have already been submitted, have already been paid for, are tainted by a Stark violation, that creates an obligation under the overpayment rule. For knowing violations, there are civil monetary penalties in the Act, up to $15,000 for each service provided. And then you also have False Claims Act liability. So taking a step back, the anti-kickback statute and the Stark law are frequently, and even though each has its own enforcement mechanism and defined penalties, they are frequently prosecuted as predicates for a False Claims Act violation. And in fact, a significant chunk of False Claims Act cases arise from Stark and AKS violations. And then looking at this slide, the strict liability, the top portion, yes, it doesn't have penalties. And if you had no intent and the act wasn't knowing, a Stark violation cannot be the predicate for the False Claims Act, which requires you to act with recklessness or deliberate ignorance. But the denial of payment or the owing of a refund for potentially thousands of claims that have been reimbursed over a 6-year period, look back period, that can take a significant chunk. And so there's real risk involved there. So with that, I'm going to turn to I think I jumped the gun there. Real quickly, Stark law exceptions. Here's a full list of them. I won't get into all of these, but like the AKS, there's a bona fide employment relationship exception. There's exceptions for physician recruitment, office space and leases, FMV for fair market value, and so on and so forth. But again, seek the guidance of a regulatory attorney when assessing whether a safe harbor or a Stark exception applies. So with that, I'm going to turn it back to, I think, Michael?
It's actually Mindy.
Actually, Michael. Mindy. We're going to go over some case studies, and I'm going to let Mindy kick it off.
Thank you, Michael. It is always helpful, I think, to discuss what type of enforcement trends we're seeing specifically in the healthcare space. And right now, there is a huge focus on the COVID era that we saw, where there was testing, vaccines, and treatment that was provided across America and at the behest of the federal government. There was a huge push for labs to test patients, for doctors to treat patients, and for people to be taken care of during COVID. And the interesting thing about 2020 through 2022 is that while all of this testing and treatment was being done, the federal government was consistently changing the rules that were in play for federal healthcare as it related to COVID. And so what we're seeing now is we're seeing a lot of enforcement. One of the most important things to know is that the federal government came back and extended the statute of limitations to 10 years for COVID enforcement cases. And so these have taken a little bit longer to get up and running. And I think that we're going to see enforcement within the COVID arena for the next 4 or 5 years to come, specifically because they have a longer statute of limitations. But this particular one that we see here is a case that came down and was just announced in April of 2025 against Vault Medical Services. They existed and they tested a large amount of individuals between May 2020 and April 2022. And they billed that treatment to what was called HRSA, the Health Resources and Service Administration Act, for the uninsured. And that was a program that the government put in place to make sure that all individuals had the ability to get COVID tests and also COVID vaccines. And if they didn't have insurance, then those providers and treatment facilities were allowed to bill those treatments to the HRSA program. And it now, the federal government is coming back and they're looking at those claims and they're trying to determine if some of those claims were in fact false claims and they were submitted for payment to the uninsured program when the beneficiaries did in fact have health insurance. And so, like we talked about earlier, these fines and the criminal or the civil penalties that go along with these cases are, they can be extreme. In this particular instance, Vault Medical Services settled for $8 million to resolve allegations that they inappropriately submitted claims to HRSA for patients that did in fact have health insurance. And so we think it's really important to pay attention to all of these things that happened during COVID for testing, for vaccines, for treatment. There were a lot of organizations that started up, specifically labs and providers that provided these types of services because the government was really pushing to make sure everybody had access to healthcare. And the reimbursement and the claim submission on these was difficult at the time. There was not clear directive on how these should be submitted in some instances and how they were going to be paid. And so we are seeing a lot of organizations get civil investigative demands asking for specific information about how they provided services and how they billed. And we're even seeing some grand jury subpoenas coming out from the government to entities trying to get additional information and opening up investigations. This is an area where I think it's incredibly important to seek out somebody that is in the government investigations healthcare space, a lawyer in that space to help kind of untangle this, because there was an ever-evolving landscape of law that was out there. And literally every 3 months, there was a different directive on how to submit these claims and how to run these tests. And so it's incredibly important to get some help whenever a civil investigative demand or grand jury subpoena come across to an entity like this to make sure that it's appropriately handled.
So, yes, thanks, Mindy. So I think that this case, along with a lot of other cases related to COVID, are instructive in that they show like how much money the government spent on these programs during the pandemic. And in fact, there is like a public list of entities and individuals who made money and who were paid money from the government related to these funds. And the government on the enforcement side has a keen interest in that list. And just like any list, when someone's ranked first to 500, there is always an interest on the ones at the top of the list. And so I think there really is a push for enforcement related to data analytics in order to open some of these issues into maybe wider scale investigations, because certain types of data analytics are important in these, meaning not just the dollar figures, but who are the patients, right? The patients register, the patients get treatment. Where are they from? Are they from the same area? Is a lab in Kentucky testing people in Washington State? Like, why is that the case? And also the point of care centers, like what it is that they're billing for in the processing of these types of claims. Are they claiming to do something that they will not be able to substantiate in the paperwork that they have? And because there's so much money, the government is going to come after it. And just like Mindy said, it seems that they think it will take them longer to do so, because it is somewhat rare to increase a statute of limitations to 10 years. That is a long time. So the next case that I wanted to bring to people's attention is a little bit different because when you think of False Claims Act cases in the healthcare space, you're thinking of all of the issues we've been talking about, services not rendered, services that are rendered but billed as at a higher level, a kickback arrangement, some type of issue that's violating Stark with a physician. And the False Claims Act is an incredibly powerful, some people would say the most powerful tool that the government has to recoup money. And it goes into a lot of different areas of law, procurement, federal procurement, and the other that we see here is related to PPP loans. And I think this is interesting because there are a lot of groups out there, including medical groups, for example, Fairfax Radiological Consultants. They're not alone in receiving PPP loans. Almost every small business received a PPP loan. And just like Mindy described in kind of like some of the confusion about the regulations related to COVID, there was a significant amount of confusion related to filing for a PPP loan, correcting your PPP loan application, having it amended. How do you get it forgiven? What are your reporting requirements? And just a myriad of issues that groups ran into. And it is something that has to be considered when we're talking about like groups that are merging with each other and groups that are going to have relationships with one another, because we have seen a significant amount of cases come out looking into the appropriateness of the PPP loans issued to tons of different groups, but we've seen a lot on the medical side as well. And this one, Fairfax, basically points to what you would say is like an improper loan forgiveness application that is overestimating the number of employees that Fairfax Radiological had. And so they got something like 6.8, and the government is saying when you applied for your loan forgiveness, you really should have only been entitled to 4.9 in forgiveness. Therefore, we want some money back. And whenever they get money back, this seems like they got away with a decent settlement of $2.8 million, because they could have been worse than that. And some of these settlements get pushed very high. But I thought this was an interesting case because it shows the real broad reach of the False Claims Act, meaning that there was a false claim made to the government in a PPP loan application and federal funds were paid to this group. And now the government is looking at it just like they look at the normal COVID testing, saying like, oh, this money's out the door. We have to go find it. Let's give these groups a CID and figure out and look into their record. So it is an interesting case because you see a lot of them. And it's also something that from a business standpoint or even like an insurance standpoint, that's not something at the top of your mind if you're analyzing like a large medical group. But it is, these loans were ubiquitous and there has been problems with them, and it's something that I think is worthy of drawing people's attention to. So that's why I included it, and I'll pass it on to Michael.
Thank you, Michael. So I went with a little different direction for my case study, and this one's anonymized because I had some involvement with this one. But you know, there's always a lot of focus, particularly when after an election year, there's a new administration. What are the enforcement priorities of the new administration of DOJ? And those are important questions. And Mike and Mindy already touched on a couple of them, right? PPP loans, COVID enforcement, cyber and privacy are significant enforcement priorities. And so on and so forth. But it's also important to remember that the False Claims Act is a little different than other criminal and civil enforcement statutes, such that the enforcement priorities, while important to know about so that you can avoid liability and risk, don't always drive things the way they do in other enforcement areas. And mainly that is because one, a lot of the cases are bread and butter cases like the one I will talk about, which just, you know, they're not hot, they're not new, but it involves AKS violations, Stark violations, or just erroneous billing in the healthcare context, right? Upcoding, double billing, providing services that aren't medically necessary, billing for phantom services, providing, you know, substandard services, and so on and so forth. That makes up a significant chunk, certainly a majority of False Claims Act cases in the healthcare context. The other reason DOJ and administration enforcement priorities, again, while important, aren't the sole driver of the False Claims Act. And the reason is the relators bar. So the whistleblowers and the attorneys that represent whistleblowers, the ones that bring qui tam claims on behalf of the government under the False Claims Act, they get a say. And the False Claims Act requires the Attorney General to investigate every qui tam complaint that is filed. So in that role, the Attorney General and the Department of Justice are reactive, right? So, the Attorney General can say, we're going to prioritize A, B, and C, but if the relator bar brings hundreds of cases about D, E, and F, DOJ is still going to have to focus on D, E, and F. Doesn't mean A, B, and C won't get attention. A, B, and C will get attention, and they're more likely to intervene and bring qui tam cases involving A, B, and C. But there is a give and take there with the relators bar, so they have a say. So this matter was a mid-sized provider, not a mega provider. They operated really in 2 states and 2.5 states, let's say. They provided home health care services, a little bit of hospice, and they agreed to pay $31 million to settle False Claims Act allegations. $7 million of that was in Florida, arising from upcoding and billing for medically unnecessary home therapy, and $23 million of that and change was due to payment of kickbacks to referring providers in another state. $31 million for a medium-sized provider with a footprint in just a handful of states. It just shows you the bite the False Claims Act can take. And in terms of defense strategies, I'll just say defense counsel in this particular matter did an excellent job. The amount is high. It could have been a lot higher, and it could have included more significant criminal remedies. Defense counsel, who sort of parachuted in at a late moment, did a good job of not obfuscating or denying the import of rock solid evidence, and instead confronted reality and put real money on the table that I think prevented what could have been worse remedies than what you see on your screen. So, bottom line takeaway, we've all talked about trends, and my partner Michael Easley is going to talk next about the Trump administration and do some tea leaf reading for you. Extremely important, but don't forget about the bread and butter cases, and the compliance the sort of affirmative compliance required to limit risk from those as well. So with that, I'm going to turn it over to my colleague, Michael Easley.
Thank you so much, team, and thank you so many of you for taking your time to be with us today. I'm former United States Attorney Michael Easley. I presided over a very busy docket of False Claims Act cases and worked closely with the Civil Fraud Division at Main Justice that Michael Paparetsky came out of. I'm the third Michael in this group alongside Mindy, and this team of strong former prosecutors is standing by to help if anything you've heard today causes you concern or gives you heartburn. We specialize in reading the tea leaves from DOJ and trying to pick up on the signals, both between court actions and things that are said in public filings, as well as public statements, and signals that the administration provides through policy guidance. We're now several months into the Trump administration, round 2, and we can tell you FCA enforcement is not being dialed back. Many of you, after you complete this call, may provide insights to those in your organization, and I want to give you a few key tidbits for you to take back to your boards, to your leadership, or to your teams. Rather than seeing some type of deregulation like we see in the crypto space or in the international bribery space, where we have seen a significant dialing back of personnel and attention, in the False Claims Act space, particularly healthcare fraud, we see signals of even more creative, more strategic, more policy-driven approach to how the False Claims Act will work. That has 2 main reasons. Reducing government waste and cutting healthcare costs are cornerstones of the president's America First platform, as well as to note that Medicare and Medicaid abuse is a very politically useful target. And so boning up and beefing up on False Claims Act expertise and manpower at DOJ would be consistent with the administration's policy goal of reducing waste and a more populist goal of trying to reduce healthcare costs for working Americans in ways that coincide with the limitations currently in Washington right now. And so as we read the tea leaves at DOJ, the two things that we typically do is we look at what they say and we look at how they staff. These two lenses give us a lot of insight. You know, we see so much turnover at the Justice Department right now. Mainstays who have been there for generations are retiring or being moved aside, but you see a lot of continuity in the civil division, particularly civil frauds and the commercial litigation branch, which is led by Michael Granston. Michael Granston has been with DOJ since 1997, and he doesn't appear to be going anywhere. That signals to all of us some continuity in how the False Claims Act will be enforced. And just last week, Granston announced a False Claims Act case alleging kickbacks paid to insurance brokers in a case we're all following very closely. And his comments were clear. Healthcare companies that attempt to profit from kickbacks, he says, will be held accountable. And he says, quote, "We're committed to rooting out illegal practices that undermine the interests of federal healthcare programs and the patients they serve." So seeing that continuity there in this division signals two things about Granston and his leadership, his vision, and how it might fit now. They'll have an aggressive posture around core areas of federal waste, billing for unnecessary services, upcoding, kickbacks, all the types of cases we're used to seeing. I think we'll also see the same sort of traditional restraint in whistleblower cases and trying to focus on those that are strong, compelling, and meritorious. And Granston hasn't been bashful about intervening to dismiss cases that they feel are not consistent with a set of factors he drafted to drive what kind of cases the administration could prioritize. We also think we'll see False Claims Act cases being used not just to reduce government waste, but also potentially to shape market behavior in ways that the administration prefers. We see this in other aspects of how the administration is doing work. We see it in the DEI context, that the administration is willing to use every tool and pull every lever to try to shape private conduct in industry. And we've yet to see that really play out in a Claims Act or healthcare, but we see an administration that's not bashful about using every tool in its toolbox. Now, the last thing I'll leave you with is there are some important judicial cross currents here. A certain number of conservative justices on the Supreme Court has expressed some skepticism about the False Claims Act's whistleblower provisions. And one court in Florida ruled the whistleblower provision unconstitutional. That case is now up on appeal. And just last week, DOJ appealed the ruling to the 11th Circuit with a lengthy brief fiercely defending the whistleblower program. So that signals yet again an administration that doesn't want to forfeit the opportunity to use these tools to make recoveries for the American taxpayer. That filing was under title of the acting head of the DOJ Civil Division. And this is something that had to have been briefed up, had to have been briefed to the Deputy Attorney General. This is a hot issue, and we see the administration fighting to protect whistleblower provisions that, as Michael Poboretsky indicated, are really the bread and butter of what we do. So what are the implications for you and your organizations? Number one, don't expect a pullback in this administration. We didn't see it in Trump 1.0. Maybe there was a little bit of tailoring in the type of cases that were brought, but we don't expect that kind of pullback this time around. The second is watch for policy signals. What do they say? How do they staff? And use that information to tune up your compliance program. If you are at all worried about something that your organization is doing, or even if you're currently facing litigation, maybe you've received notice that you're under investigation, a civil investigative demand, maybe you've received a complaint, it's not too late for us to come in and do proactive compliance counseling to try to help you get ahead of further problems. It can help you limit the scope of any future corporate integrity agreement and can really serve to get you in a better position going down the road. This team of former prosecutors works closely together. We're following every signal we can, and we were willing and able to do that kind of proactive policy and compliance counseling to get you out of trouble or keep you out of trouble. We'd love to hear from any of you. So we're happy to continue talking, but there is another way you can help mitigate risk, and that's through looking at how you insure these issues and being creative to find solutions. And with that, I'll pass the baton.
All right, thank you very much. So I'm going to jump into the next section, which is really looking at what options there are in the marketplace. And I guess just to start off with, I think to recap what we've heard from the McGuireWoods team is that this risk is not waning. It's certainly not going away, even with the new administration. We've also heard that there's some evolving trends that continue to plague our healthcare industry as they continue to try to navigate the world of enforcement actions. And in my role as the national practice leader for AON, I get the privilege of talking with health systems and hospitals around the country about what their most concerning risks are, both from an adequacy or even availability to transfer that risk. And helping them with those discussions really is a big part of what we bring to the equation. So I'm going to talk a little bit about what's out there in the marketplace and also touch on a new development that we actually partnered with McGuireWoods to drive into the insurance marketplace. So let's just kick things off. Historically, there has been some element of coverage available in the marketplace in a few areas. One is in directors and officers liability policies. A lot of policies will include, I call it a sliver of coverage, and that sliver is designed to really address defense costs only. And it is typically subject to a sublimit of $1 million with a $1 million retention and a 50% coinsurance. Sometimes you can stack that, so you'll be able to get more than the $1 million, but truly it is just a sliver of coverage because it's designed to only cover the defense and not cover any other portion of a settlement or fines and penalties or any other damages that are owed. So the other option is to look at standalone policies. And historically, there's been two standalone coverages that are most prominent for health systems and hospitals. And those were provided by Beasley and Ironshore. There was a couple of other options available for some smaller risks, physician practices and so forth. But for hospitals, health systems, mainly it's Beasley and Ironshore. Those policies have also been mostly focused on providing affirmative coverage for defense, although they also cover some elements of settlement. But there's been some significant restrictions in those forms historically that create headwinds, which we're going to talk about in a few minutes. And the maximum limits that were available under those two policies were $10 million. But really what I've heard and others, is that the larger systems have really expressed concern around both the adequacy of limits, given the adequacy of the coverage because of the restrictions that we know are present in some of the existing historical policies. So as I mentioned, we're very happy to share that the Lloyd's of London marketplace came to the table and worked with us to provide a new solution to address regulatory risk for healthcare. This new product is called Cosantor. They've provided $50 million of limits, which is much more aligned to the severity of these settlements and the value of some of these enforcement actions. It is available in a minimum of $20 million limits, and insureds can purchase increments of 10 up to the 50 million total. There is a retention of 10 million, which may appear large for some, but that aligns with the severity of, as I said, of these claims, and also to avoid sort of trading of dollars. And it also aligns to the fact that the coverage is exceedingly broad. This policy, though, can also sit excess of those other forms that are available. So Beasley and Ironshore could write a $10 million primary to cover the defense costs and then have this Cosantor product sit excess. The policy is underwritten by a consortium of Lloyd's markets, those that are listed on the form here. But most importantly, and this is really the critical piece of this that we're going to talk about why it's important in a couple of minutes, but the form was manuscripted in conjunction, in partnership with McGuireWoods and other attorneys who've really litigated, quite frankly, against Beasley and Ironshore on some of the problematic areas of those two policies. So this policy form has been manuscripted to address those problematic areas. And a few things that are listed here, again, we're going to talk about some of that litigation in a minute. But the definitions of wrongful act, loss, claim, investigation, and defense costs have been expanded or refined to address some of the nuances of the enforcement actions so that they align with what we are seeing in current enforcement actions. Next, the fraud exclusion, which you would assume is very important because this is all about False Claims Act, which is alleging fraud. The fraud exclusion has been narrowed significantly to not be an issue or to be able to be used by the carrier to deny coverage. And then lastly, we know that consent to settle and cooperation is important because oftentimes these claims, these situations go under seal, as we've talked about. And so the insured or the target hospital is unable to really talk through to violate the cooperation clause. The Cassandra policy has been amended to address that issue. So I'm going to turn things over to Shelby Gilbert to talk about what he has seen specifically in working through some of those coverage problems with some of the forms that have historically been around in the marketplace.
Well, thank you, Martha. My name's Shelby Gilbert. I am in the insurance recovery practice at McGuireWoods. At McGuireWoods, we don't represent insurance companies. We only represent policyholders, and we have seen a lot of the forms that Martha has been talking about that a lot of our healthcare clients in particular have purchased over the years. And one challenge that many of our clients face when they get hit with a False Claims Act investigation or a Stark Act claim is which of their insurance policy forms apply. Most healthcare companies, no healthcare company has a form called False Claims Act insurance policy. So what we have done historically is looked to directors and officers liability policies, errors and omissions policies. Sometimes if there's a whistleblower allegation, employment practices policies, we've been able to find some coverage there. And many of our clients have purchased some of these other products that Martha mentioned that provide some level of billing, errors, and omissions coverage. But that's one of the first challenges that we sometimes face. And a lot of healthcare companies may think, well, I don't have coverage for False Claims Act investigations. Sometimes you do. And it's important to, when you get hit with an investigation, to look at the coverages right away and talk to counsel and talk to your broker to make sure that you should be placing your carriers on notice. But as Martha mentioned, one problem that a lot of these forms have is that the coverage is often set out by a number of defined terms that are common to most directors and officers policies. And that's where we typically find the most coverage for our clients. And that wrongful act definition is usually very broad. It usually says something like any act, error, or omission, but it doesn't specifically enumerate coverage for False Claims Act claims. And alternatively, there are some forms that go on further and say that False Claims Act coverage, if there is any, is limited to billing, errors, and omissions. And that's a defined term in the policy. There are a few forms in the marketplace that provide broad exclusions for any claims arising under the False Claims Act. Most policies don't do that. So we argue that forms, unless they specifically exclude False Claims Act, provide full coverage, but insurers always push back and say, well, that was never our intent. So in practice, because of some of these issues and because it can be a gray area, we have had to litigate a number of these claims on behalf of our clients. Now, I've included some cases on this slide where courts have found that notwithstanding some of these challenges, that there is coverage for False Claims Act settlements. One issue that we see time and time again is that the policyholder puts in the claim for coverage for the False Claims Act, and the insurance company comes back and says, well, there could never be coverage for a False Claims Act suit because a False Claims Act, the purpose of it is to recoup funds. It's a restitutionary act. But if you look at the statute itself, 31 U.S.C. 3729, the only remedies that are available for a False Claims Act violation are damages and civil penalties. Well, damages are expressly covered under most directors and officers' liability policies, and they are different in character from restitution. And the Seventh Circuit has actually agreed with that in a recent ruling in the Estellas case, where Chubb argued that, well, False Claims Act remedies are restitutionary. And not only that, if you enter a settlement, like many policyholders do, with the government, and part of the settlement is characterized as restitution, you can't get coverage for any of the settlement, and certainly not the part labeled restitution. Well, the Seventh Circuit said that the reason that people put restitution or characterize it, and the DOJ does that in settlement agreements, has nothing to do with what the remedy actually is. It's just due to IRS regulations, and found that the entire settlement in that case was covered. So very helpful language from the Seventh Circuit. We've also have cited a number of cases here where a number of insurers have said, well, we've got language that says loss shall not include an overpayment, or loss shall not include the return of funds to the government. Well, courts have pushed back on that in some of these cases, and have said, well, if a relator is actually receiving the settlement, well, that's not a return of funds to the government. So many of these cases push back on that. But again, you have to get into litigation sometimes with the insurer to really maximize the value of the policy before they're willing to pay. Same goes for intentional acts exclusions. Courts have said that if you settle a False Claims Act claim, that doesn't necessarily mean you've settled an intentional act, and it's not automatically excluded. But that's one issue that you have to litigate under most existing forms in the marketplace. Insurance companies won't roll over. A number of other issues that arise that are not addressed in most forms is, well, when do you provide the insurance company notice of a claim? And there's usually a claim definition in most policies. Sometimes a claim means a subpoena or civil investigative demand. Now, if it does, and you're in the in-house legal department and you don't provide notice of that subpoena to your insurer, that can result in no coverage. Alternatively, your policy might say that a subpoena and a CID don't trigger coverage and do not qualify as a claim. And then you spend millions and millions of dollars in the investigation and find that there's no coverage. Most of the forms don't deal with issues like sealed complaints. When the government says you can't share the complaint with anybody, how do you tell your insurance company about it? So a lot of the forms that are out there just don't deal with those types of issues, and they aren't very realistic when it comes to just cooperation conditions. You're supposed to cooperate with your insurance company, but in a confidential False Claims Act investigation, it's not always easy to tell them everything and to share all the presentations that you're receiving from the government in a confidential investigation that tell you what the claim is all about. And I think the last thing I'll mention before I pass it back to Martha is that in a lot of the forms, there seems to be a misalignment of interest. And what I mean by that is that the carriers may say, well, we'll give you maybe $1 million in defense cost coverage. But for the particularly larger providers, that's really not enough coverage to really make a meaningful difference if you're talking about one of the larger settlements that Michael talked about earlier in the presentation, where the settlement could be upwards of tens of millions of dollars. Other issue arises where the carrier may say, well, you have to use our panel counsel or some other law firm that doesn't charge more than $300 an hour. And while that may have been a lot of money in the late 1990s, it's hard to find paralegals in many states that bill out at those rates. And it creates perverse incentives where the carrier's trying to drive down legal costs and force you to use firms that may not be qualified to handle a False Claims Act investigation, which has the perverse effect of driving up your liability. So, Martha, do you want to compare some of these forms? I know we're running up against the hour, but...
Yep, sure, Shelby. And I guess just to summarize this, there's a lot of content on the next few slides, which I won't go through line by line because we are running against the time slot. But really what I think I want to make sure that everyone is left with is there are various options in the marketplace. But as I mentioned earlier, and what Shelby just reinforced, is that we've seen a lot of problems with Beasley and Ironshore and how those forms respond in real life to some of these enforcement actions. So using the lessons that have been learned with trying to get coverage, get recovery from those forms, we've worked with the McGuireWoods team to really draft the language in the consent reform to address some of those nuances. It's not saying Beasley and Ironshore aren't worth considering, but sort of proceed with caution and with eyes wide open. But these slides just kind of go through some of those nuances that, in fact, we know are important as you get into some of the enforcements and how they're brought. But one of the most critical things that Shelby just mentioned is this hidden exclusion in the definition of loss that a lot of the carriers, Beasley and Ironshore, will raise, and that is whether or not a settlement it constitutes return of funds, refund, disgorgement, or restitution. So important to note, very important to understand the forms, how they will respond to these actions in real life. And just encourage you, just as it was mentioned earlier, to engage qualified counsel, obviously qualified broker partner to help navigate the coverage availability. So with that, I know we are out of time. I guess I will open it up to any other questions. We've got one that came in that I want to make sure that we address. So I'm sure one of our McGuireWoods partners can address that. The question regarding the prosecutors and whether they're likely to bring FCA cases based on DEI compliance representations by federal contractors or recipients of federal funds. So I'm not sure if we want to have somebody respond to that. I'm not sure, maybe.
Yeah, I'm happy to address that briefly.
Perfect.
The administration and one of President Trump's executive orders tipped their hand in not a subtle way that they want to bring False Claims Act cases bottomed on false compliance with anti-discrimination provisions, including DEI, whatever that means. In one of the relevant executive orders, the administration indicated that a failure to comply with the anti-discrimination laws, including eradication of DEI programming, that would be considered material for False Claims Act purposes. False Claims Act has 4 elements. One of the elements is materiality. You know, the false statement or false certification needs to be material to the payment of a claim. The executive order says, sort of by proxy, by declaration, violation of this certification, a violation of this provision would be material for False Claims Act purposes, tipping the administration's hand that they want to use the False Claims Act to enforce their anti-DEI agenda. The courts are going to have a say here. Courts like to do their own materiality analysis, and as instructed by the Supreme Court, a 2016 case called Escobar, where the Supreme Court provided detailed instructions to lower courts on how to assess materiality and indicated that labels that the bureaucracy chooses are not the end all and be all. The court has to decide on its own whether a violation is material or not. And courts also have been opining and ruling on in a host of suits about these anti-DEI provisions and executive orders. So that is a very live issue, and I do expect to see some False Claims Act enforcement arising from such certifications. Thank you.
All right, I think that's it for the questions. And since we are out of time, I'll go ahead and wrap things up and just thank everyone for joining. If there are any questions remaining, feel free to reach out directly to any of the presenters that are listed here. And with that, thanks again. Have a great day, and we'll see you again.